Good morning, everyone, and thank you for joining us today. My name is Denise Keele. I'm the Executive Director of the Michigan Climate Action Network. I will serve as the moderator of today's press conference. We are live streaming this event, and I will take questions at the end from the media. First, I would like to recognize the Michiganders from all walks of life standing here with us today. In person and online for over a decade, tens of thousands of Michiganders have sent comment after comment to different regulators, elected officials, with a repeated and unified message, which is, shut down and no oil tunnel. Okay, you're gonna practice that one. No oil tunnel, right on. Today's legal actions are one of many in the larger fight against Canadian fossil fuel giant Enbridge Energy in multiple states. In 2019, after significant damage to an anchor support was revealed, Michigan Attorney General Dana Nessel filed for a preliminary injunction. After 7 years of Enbridge's procedural maneuvering, we are currently awaiting a United States Supreme Court decision on whether that case will return to its rightful jurisprudence in state court. Despite the known risks, Enbridge continues to pump 23 million gallons of crude oil in the aging dual pipelines. In 2020, Michigan Governor Gretchen Whitmer ordered a shutdown of those dual pipelines, citing the environmental risks. She revoked and terminated an easement due to the threats of contamination and the source of drinking water for more than 40 million people. Despite being responsible for 33 separate incidents that have dumped over 1 million gallons of oil into our ecosystems and communities, Enbridge continues to violate that shutdown order as we speak today. Shame. In the midst of all that, a reasonable solution would be to just plan a shutdown. But instead, Enbridge's response to the myriad safety and environmental concerns is to build a risky and massive new underground oil pipeline tunnel that has immense environmental consequences across the Strait of Mackinac, a place of critical importance to tribal nations. That tunnel would lock us in to unnecessary fossil fuel infrastructure and carbon emissions equivalent to 19 million gas-powered vehicles each year. That is not the future that Michigan is set out, and our appeals are here around the tunnel project today. Our cross appeals seek to reverse the Michigan Public Service Commission's flawed decision to approve a permit for Enbridge to build a tunnel for its Line 5 pipeline beneath the Straits of Mackinac. 4 tribes, including the Bay Mills Indian community, along with Michigan Climate Action Network and Environmental Law and Policy Center, challenged the permit before the Michigan Supreme Court today, arguing that MPSC incorrectly limited the scope of its review and assessment under the Michigan Environmental Protection Act. Here with us today to discuss those arguments are going to be Whitney Gravelle, president of Bay Mills Indian Community, and Dave Scott, senior attorney at Environmental Law and Policy Center, representing its members and the Michigan Climate Action Network. In a separate appeal, Flow Water advocates argued that the Michigan Public Service Commission should have rejected the tunnel under common law public trust doctrine. Here with us today to discuss that argument is Riyaz Kanji, representing Flow Water Advocates. But first up, it is my honor to welcome to the podium President Whitney Gravelle, Bay Mills Indian Community.
Feels weird to be facing this way, but Ani Bojo, Giwedi Nagabo, Kwayin Dishnakas, Ganush Nakani Nindonjaba. My name is the woman who stands in the north. My English name is Whitney Gravelle, and I currently serve as the president of Bay Mills Indian Community. I am here today on behalf of the 4 intervening tribes, but also representing the 5 treaty tribes that are signatory to the 1836 Treaty of Washington. We attended arguments today and unfortunately heard the Michigan Public Service Commission share that there were no protected rights at stake involving the case before the Michigan Public Service Commission, and that is absolutely not true. Not only are rights at stake for every citizen in the state of Michigan, but rights are at stake for tribal nations who are signatory to the 1836 Treaty of Washington. There are cultural resources in the Straits of Mackinac that are at risk There are ancestors that are buried along the shoreline that we are attempting to protect. There are natural resources, including those of Lake Whitefish and Lake Trout, that are at risk, that are diminishing the tribal treaty right that exists in these waters. A tribal treaty right that has actually existed since time immemorial. When we talk about treaty rights, often people think of them as contextualized as something that only belongs to tribes, but it is really the sister of the public trust doctrine. We are trying to preserve that natural resource protection so that all of us can continue to enjoy the waters of the Great Lakes, enjoy what it has to offer, because that is our inherent right as we reside here. Bay Mills Indian community cannot be Anishinaabe, we cannot be Ojibwe, any other place than here in the state of Michigan. And so our relationship with the land, with the water, with those natural resources that are protected under the public trust doctrine are very important to the continuation of our culture, of our language, and of our people who have resided in the state of Michigan long before there was ever a written history or before there was any time recorded. The arguments today were disheartening. You know, we continued to hear a lot of propaganda put forward by Enbridge and Line 5, propaganda that is not true, that is inherently false. And so as we reflect upon the arguments and what's at stake for every single Michigander here in the state of Michigan, I really ask people to examine the facts that exist out there, the independent facts. It does not come from us, it does not come from Enbridge, it comes from independent experts who have shown that we do not need Line 5 here in the state of Michigan. We do not need its product, we do not need Enbridge, and in fact, what we do need is the water of the Great Lakes. And it's something that we all rely upon. So with that, I just want to say thank you to all of our supporters are here. We will be watching this case closely, and this is only one of the many fights that we will continue to carry on behalf of not only the tribes, but every state of Michigan citizen here in the Great Lakes. So with that, I will introduce Dave Scott with the Environment Law and Policy Center. Thank you.
Thank you, President Gravelle, for your impactful words and for your teaming up with us on this. Good morning. My name is David Scott. I'm an attorney with the Environmental Law and Policy Center. This morning, I had the privilege of arguing before the Michigan Supreme Court about how important it is that Enbridge's tunnel project gets the thorough environmental review that Michigan law requires. I've never been in a courtroom that jam-packed with people, so that's a testament to how important these issues are, how passionate people are, how vital it is that the law is followed here and the environmental review is done. Running an oil pipeline through the Straits of Mackinac has always been a terrible idea. Enbridge's plan to build a tunnel under the Straits to keep Line 5 operating for another century only makes the terrible idea an ongoing problem for future generations. It prolongs oil spills, increases greenhouse gases, affects public trust resources. That's why it's imperative that the tunnel project undergo the full and fair review under the Michigan Environmental Protection Act. And that's what we are arguing about to the Supreme Court this morning. The justices listen carefully to our arguments. They ask good questions. They're clearly taking these issues seriously, and we await their decision eagerly and look forward to it. We hope that the court will send this case back to the Public Service Commission with directions to conduct a full and fair environmental review that needs to be done under the Michigan Environmental Protection Act. Before I pass this off to Riyaz, I want to say some quick thank yous. I want to thank all the members of ELPC in Michigan and throughout the Midwest. I want to thank our great client, MyCan, Denise and her team, and the excellent work that they do. I want to thank our tribal partners, President Gravelle, others, and the Earth Justice legal team, especially Adam Merchensky, who did a great job arguing with me this morning. I want to thank all the lawyers, all the advocates, all the people here who are so passionate and working so hard on this issue. It's really, really important. And I want to thank Flo, and I want to thank Riyaz, who did an excellent job in the second argument this morning. And with that, I'll pass the baton to him, as he just walked in.
Thank you very much. It is such a pleasure and privilege to be here. I will start with where David ended, which is to say by way of thank you. You know, many people in this room have been involved in the fight to shut down Line 5 for a very long period of time. And we have an incredible assemblage here. We have so many wonderful advocates, political people, lawyers, just supporters. And this is, you know, often been a challenging fight. It is obviously a fight that has gone on for a very long time. Sometimes it taxes us. It feels like our cross to bear. But what gives us strength and what gives us undying hope is the tremendous feeling of support and community and the conviction that we are right and that right people are joined together in this fight. It makes a world of difference. I will tell you that every time I am fortunate enough to go into court and to stand up and make these arguments, I carry everyone with me, and I carry that feeling of strength and conviction and just the knowledge that I am fortunate and lucky enough to work with some of the best people on earth in terms of caring about the earth and our resources and our history. And it is a tremendous privilege. It's a great privilege to represent Flow in this matter and to work so closely with the tribes and other environmental organizations who have all been working together so hard. It is sometimes difficult in fights where you have a lot of different groups and interests. That has not been true of this fight. This has been a fight where we do have a lot of different groups and we do have a lot of different interests and perspectives, but people are very united in this goal. I will just say a few things, and they will go in part to the what we heard at the argument this morning. First, we appreciated that argument. We appreciated the Michigan Supreme Court. I feel like the justices were taking these issues with the commensurate seriousness that they deserve. The court was well prepared. The court asked good questions, and it was, I will say, and I had this thought, I'm sure I'm not the only one, it was nice to finally be in front of the Michigan Supreme Court, which is the court that should also be deciding, ultimately, the fate of the dual pipelines. And, right? The fate of the dual pipelines in the Straits of Mackinac is a core Michigan issue. It is an issue of fundamental importance to the state. The battle against the dual pipelines, the legal arguments, have been shaped based on the public trust doctrine and the tremendous importance of safeguarding resources that lie at the heart of that doctrine. Because it is a core state interest and the legal arguments turn on core state law doctrines, it has always been the thought and understanding that the Michigan Supreme Court would ultimately decide the fate of the dual pipelines. Enbridge and its allies have engaged in, and I will say this, a masterful campaign to wrest that decision-making away from the courts that have the greatest interest and stake and that represent the people of the state. And that has been a shame. And we have lost time because of that. And obviously in a fight like this, time is of the essence. But we are not going to give up on the fight to ensure that the real legal issues in this case are decided by the courts that should be deciding them based on the issues that warrant decision. And the relationship between that and the arguments we had today is this. In terms of the fight over the tunnel, there's obviously been a tremendous amount of work done by all the groups that are represented here in opposition to the tunnel, because there is an understanding that the tunnel itself poses very significant risks. and that that the tunnel needs to be assessed on its, that's not my phone, is it? The tunnel needs to be assessed on its own merits. Enbridge is doing what Enbridge is very good at doing, which is shifting attention away from the real issues, right? And so this notion that, and you saw it in John Birch's legal argument today, and John Birch is a skilled lawyer, and he's argued a lot of cases in the U.S. Supreme Court. He was the Solicitor General of Michigan. In that first argument this morning, which is about standard review and scope of review, legal issues, he barely spent any time on the law. Like, he really didn't. He went straight to, well, this case is about the dual pipelines versus the tunnel. And even though we, Enbridge, think that the dual pipelines are totally safe, right? And you heard that. They are totally safe. I forget how many zeros there were after the decimal point, but there were a whole pile of zeros, right? It's totally safe. But we care so much about the environment that we want to build this tunnel. And all of us in this room, we're the ones who don't care about the environment, right? Because we are opposed to this tunnel. And, forgive us if we are a little bit skeptical about the safety claims that Enbridge makes, right? And when Enbridge says that the tunnel can be constructed and operated completely safely, forgive us if we're the ones who are saying, well, that needs to be determined, right? That needs to be assessed in a rigorous way. And what has happened to date has not been in a rigorous way. And what we are asking for is that when it comes to the public trust interests, that an agency that has expertise and that is charged by law with assessing those public trust determinations be allowed to make those determinations. And I will tell you, that is not the MPSC. And, right? That is not the mission of that agency. And that is not how that agency has discharged its responsibilities to date. And I said this a few times in the argument, and I am blessed to have my son in the room, and he will tell you that I often will repeat myself, especially when it comes to stories. But so I will say it again. It really struck me in getting ready for this argument that their testimony, the tribes placed in the record, trying to draw attention to about the impacts that the tunnel could have on tribal fisheries. And I don't need to tell you how important the fisheries are to the tribes. I don't need to tell you how much the Great Lakes fisheries are struggling for survival. And when you have a tribal fisheries manager talking, I'm getting the hook here, so I'll be quick. When you have a tribal fishery manager talking about how you could have spawning grounds wiped out when we have so few of those left, and then you have an agency that doesn't even mention that in its discussion of the issues, that tells you everything you need to know. So thank you to all of you for all the support, all the love, all the hard work and creative thought. I know all of us will stay in this fight for both the tunnel and the existing pipelines, and we will stay in this fight until the right thing is done. Thank you very much.
Nice. Thank you so much. Thank you so much, President Gravelle, David, Riyaz. We are so grateful that the Michigan Supreme Court got to hear these excellent arguments today. Thank you, guys. Now we play a game that we're used to, waiting for a court decision. But in the meantime, there is still one more agency that has a pending permit. You heard a lot about this in the arguments today. Enbridge has a current wetlands permit pending before the Michigan Department of Environment, Great Lakes, and Energy. Keep in mind again, this tunnel, folks, calls for 6 years of intensive construction across 15 acres of interconnected wetlands, using a 24-foot tunnel boring machine to excavate a 4-mile tunnel under the straits and remove over 400,000 cubic yards of material. We need all of you to urge Eagle Director Phil Roos and Governor Gretchen Whitmer to take the hard look, because we believe that when that hard look at these permits is taken, that it will be common sense to deny the wetlands permit. There are cards and actions here for everyone here to take, and I'll now open this up to my speakers, Riyaz and David and President Gravelle. Please come back up, because I'm not going to answer all these questions. I bet they got some questions for you. If media are here, if you could please state your name and your outlet and maybe who you would wish to answer that question. Yeah, go ahead, Valerie.
Jane, Riverwise Magazine. When do we expect the Michigan Supreme Court decision to come in?
I think one of the lawyers should take that one.
I think we're hopeful that it'll be by the end of the court's term, which would be this summer, June, July.
Okay, that's disappointing.
Yeah.
Disappointing in the sense, that's actually would be fast for a court.
For the folks at home.
Okay.
Other questions? Me- Sure.
Kelly House with Bridge, Michigan. Probably any of the three lawyers up there could take this, but your groups are looking for a shutdown, and obviously the Enbridge lawyer today essentially argues that the real question here from their perspective is tunnel or keep operating line 5 in the strait, and they're trying to make the argument that federal preemption applies. I know you touched on that a little bit before, but what is your response to that argument from them?
Do you want to start?
And step up to the mic, because you
Sure. Yeah, thank you, Kelly, and thank you for all your excellent reporting over time. The two things, I could go on for a long time, but I'll try to be quick. First, it is a completely false narrative. If the dual pipelines are as dangerous as we all understand them to be, they should be shut down. The tunnel will lock in that the dual pipelines remain in operation for at least a decade or more, as I said, because Enbridge's whole thing is the oil has to keep flowing. So we will keep it flowing through the dual pipelines until the tunnel is built. And it will, they've said 5 to 6 years in their projections. You can bet that that's going to be 8 or 9 years at least, and then you add in the litigation challenges. I was being conservative in saying a decade. We're talking about more than a decade, where you put off the reckoning of what should actually happen with the dual pipelines. And that's the second point. As long as the pipeline's out there, it's like this shiny object, and they've been able to use it to forestall a serious conversation amongst policymakers about what should really happen. If you put the tunnel off the table, you end up having that serious conversation. I mentioned in my argument today, Canada has to be involved in that. Canada has been a menace in this litigation, both here with the Bad River Tribe. They have been pounding on the courts to keep the pipeline open. But I think if Canada starts to seriously think about the fact that, well, you don't have a tunnel, do you really want to keep the line operating indefinitely? That will force some more sober-minded thinking on their part as well. And there are plenty of other alternatives. So what I think really needs to happen is we need to have our governor, the Ontario Premier, the Quebec Premier, national leaders in both countries actually sit down and talk about a regional economic solution. And it can happen. It can happen without people suffering. It will mean a reduction in Enbridge's profits, because not all that solution involves Enbridge infrastructure. But at the end of the day, in terms of the meeting people's needs, it can definitely happen without a tunnel and without the dual pipelines.
I just want to follow up. Yeah, thank you. I want to follow up as well. Enbridge has placed the moral obligation of its bad actions on the shoulders of everyone else. And so when they talk about the tunnel versus the pipeline, it is truly their bad actions that they are asking everyone to resolve for them. Bay Mills Indian community has participated in all of the permit processes. We have seen Enbridge use this trick in front of multiple state and federal agencies to say, well, we received a permit here, give us a permit here as well. If you don't approve this permit, you are the ones risking an oil spill, not us. We've seen them do it to the Bad River Band, leveraging their active trespass on their reservation as a means to grant additional permits for their continued bad actions. And so that question has been presented in front of us and in front of multiple state and federal agencies. And it's a trick question, and it's a question Enbridge wants you to answer because they can't answer it for themselves.
Listeners with Gomwer. Enbridge said today that if your argument pulls through, then it might lead to another 5 or 6 year delay in the process to go back to PSC. Is that what your timeline looks like? And what does another possible delay mean for these pipelines and tunnel?
Sure, I'll take that. Well, as Riyaz said in his argument, Enbridge is going to delay this either way. Their construction project's going to take a decade, and they're planning to run the dual pipelines throughout that period. So there's a little bit of irony in that argument they were making. All that we are asking for is that the right process be followed, that the legal requirements be followed, that the agencies do their job under the statutes, the MPSC and EGLE, and we hope that that's going to happen sooner rather than later. We're working it as hard and as diligently and as quickly as we can to make that happen. And we hope the court rules soon this spring, and we look forward to that opinion.
Can I add one? I'll add one thing to that. This is really, I'll try not to get too deep into the weeds, but this is really important to understand. We wouldn't be in this place today. We wouldn't be 7 years into this whole fight over the tunnel if in 2018, and we all remember what happened in the lame duck, rush to judgment and passage of the legislation. There was a very clever game that they tried to play in 2018, which was to pretend that the public trust and the Great Lakes bottomlands were not implicated by the tunnel. And there was this legal theory developed that because the tunnel's underneath the lake bed, that's not a public trust resource, that it's not in the bottomlands, which is just not right or wrong. But what happened because of that is that the whole first stage of permitting, the EGLE permits that were issued in 2020, the approach to this, they tried to proceed as if the public trust wasn't involved. And this group, everyone here, has called them on that. And what has now been said is, no, the public trust is involved, so we have to make these assessments, which is why EGLE is now actually, this time around, doing the right thing and making these determinations. But we don't want to hear anything from the other side about delay or how long this takes, because we lost 7 years through this ill-founded legal theory. EGLE now has all this in front of it and is working very hard to make the determination that is actually called for under law.
Eric Isaac, Bloomberg Law. This may be a philosophical question, hopefully not too philosophical. What ends up moving a court more, do you think? The real world implications, like the current segment continuing to operate, or the nuts and bolts of the legal arguments?
Riyaz for the win.
Do you want to start? You're good.
I think the simple answer is it depends on the judge. I mean, on the panel, the justices this morning, some questions were about real-world implications. Other questions were about legal. Some probably sounded like technicalities, but important legal issues. And so one judge is different from another, and I think we saw a diversity of concerns on the court this morning in their questioning. But it is a philosophical question for sure.
Yeah, I agree. And first, thank you for the question. And Bloomberg, you guys do wonderful work. Jordan Rubin was an old friend, and we appreciate the coverage. I think that when you get to the highest court, be it like the state Supreme Court or the U.S. Supreme Court, that you have to be attentive to both, because I think the courts view their role both as interpreting the law, but as making policy going forward. And that is that ties back into what I was saying earlier. An issue like this that is such a fundamental public policy issue in Michigan, and that involves core doctrines of Michigan law. That's why ultimately the fate of the tunnel and the fate of the dual pipelines really should be decided in a fair world by the Michigan Supreme Court.
And I just want to add one thing. If the court does take into consideration real-world implications, they have not yet heard the tribal implications involved in this case. Much of that was excluded in the lower court with the Michigan Public Service Commission. Testimony was not, admitted on behalf of the tribes. And so there are other implications that the court should consider if that's the route it goes. And I hope they take that into consideration when they make a decision.
Yeah. One more implication there. The other real-world implication is climate change is here. And we're being denied the opportunity to even investigate the greenhouse gas emissions and the alternatives in what should be the short term that we're still using fossil fuels. And so just being able to get that argument in front of our agencies and to have that kind of evidence presented is what we really need to also make happen on that. Other questions from the press? Any media? Go ahead. Okay, that's okay.
Considering the erosion under the Bad River and the aging
So I don't.
pipeline here in Michigan, has anyone ever suggested to Enbridge that it might be more feasible just to build a pipeline in Canada?
Yes.
Yeah.
Look, and the your question points up a really important consideration, which is that the bulk of the energy on carried on Line 5 benefits Canadian interests, and Canada, however, has been very unwilling, and for good reasons. Look, there is a lot of opposition in Canada to build a new pipeline. Completely agreed with that, right? And Canadians don't want to bear the environmental risks of this line, but neither should we, right? And we should not be building brand new fossil fuel infrastructure in this day and age and locking in the transport of that fossil fuel for another century to largely serve Canadian interests. We shouldn't be doing it to serve our interests. We just shouldn't be doing it. But especially the irony here that Canada won't take the environmental risk, wants us to bear it all, should, I think, and I don't understand really for the life of me why with our policymakers that doesn't resonate more. Yeah.
Okay. If there's any more questions from the media or the press, we'll take that piece, and then we can have an informal discussion with the advocates that are here after that. So just media, press. Okay. Thank you all so much for coming today and for asking these great questions. The coverage of this is so important because this is a people-powered movement, not a fossil fuel money-powered movement. And so we appreciate you guys coming down and all the great questions today. Thank you everyone that is online, that has been watching today. Please follow Oil and Water Don't Mix, Flow, Michigan Climate Action Network. I shouldn't have started listing them because I'm going to forget somebody. ELPC, all of us have a coordinated and singular action that we are taking now. Again, as we await the court's decisions at multiple levels, we still have one agency that has yet to give a permit. They are taking it seriously from all accounts, and we need your pressure on our Eagle department now to request that they fully investigate these issues and ultimately, we hope, deny this permit. Thank you all again so much for coming out today.